Welcome back to the LAWSTACHE channel. My name is Anton and I'm a criminal defense attorney here in the Southern District of California. Now on this channel, I bring you case law from around the country, but I try to focus on the Supreme Court and the Ninth Circuit. And every week I discuss a case that interests me, and I hope it interests you. And of course this week, it's a popular topic. We're dealing with Miranda. When I mention the word Miranda, just about anyone in the United States knows exactly what I'm talking about. It's the right to remain silent, anything you say can be used against you in the court of law, and so on. Those are your Miranda rights. And of course, you get a right to have an attorney present next to you when you're being questioned. Now, today we're going to talk about the case that followed Miranda, where the Supreme Court explained to us what exactly does a person need to say to the cops if he wants an attorney being next to him. So let's stay tuned and figure that out. In this video, we'll be discussing Davis versus United States, a Supreme Court case from 1994. Now, you will notice right away that the facts are a little bit different than usual. We're dealing with a naval base. So we're in the military court initially. It is the sailor who is being questioned, and he's being questioned by NIS, the Naval Investigative Service. Now, the Supreme Court tells us that the Fifth and Sixth Amendment rights, including Miranda, apply on the naval base when a sailor is being questioned. So you don't have to worry about those facts. None of the parties are arguing against it, so Miranda does in fact apply. So here are the facts. Mr. Davis and another sailor are playing a game of pool. They bet $30 on the game. When the second sailor lost, he refused to pay the $30. So Mr. Davis beat him to death with a pool cue. Now the next day, the body is found and Mr. Davis is taken into custody. Now, anytime we're talking about Miranda cases, we're dealing with confessions. But something to remember, there are usually other evidence involved as well. So in this case, there was a bloody pool cue that was found on Mr. Davis. And there were some conversations that Mr. Davis had with others describing the fight. But let's go back to the confession and to the interrogation. Before I tell you what happened in this particular interrogation, something to remember about Miranda, something that people often get confused. The only time the cops need to read you your Miranda rights is if you're in custody and being interrogated. So here are a couple examples. If you're on the street and the police officer comes up to you and says, "Hey, can I speak to you?" and you start chatting about some crime, well, he doesn't have to give you your Miranda rights because after all, you're not in custody. In custody meaning, are you being free to leave? If you are not free to leave, then you're in custody. It's not necessary that you're in handcuffs, but usually you will be if you're in custody. Now, the second part is interrogation. Interrogation means that the police officers are asking you questions that will incite incriminating statements. So here's the second example that I'm going to give you. This is the one you see all the time in the show Cops, where an individual is being handcuffed. During that whole process, an officer is reading him his rights. You have a right to remain silent. Anything you say can be used against you in the court of law. You have a right to an attorney. One can be given to you for free if you want one. Well, the point is, after he's handcuffed, usually in the show, that person is then put into the vehicle. He's not questioned. So technically, Miranda does not apply. The officer never needed to read the Miranda rights. So in my own personal cases, my clients often come in and tell me, when I was being arrested, they'd never read me my Miranda rights. Isn't that against the law? And the answer is no, they never needed to read you your Miranda rights. So let's go back to this particular case. In this situation, there's no question about that Mr. Davis is in custody. He's being interrogated by NIS. But he waives his Miranda rights. After the officers read the soldier his Miranda rights, he says that he's willing to answer the questions. After about an hour and a half, he says, maybe I need a lawyer. So the officers ask him, does that mean that you want a lawyer? Or you're just talking about that maybe you want one, but you're not sure? To which he says that no, he doesn't need one, we can continue talking. So then they continue talking, and after about another hour, he finally says, yes, I need an attorney next to me. And at this point, the whole interrogation ceased, and the officers stopped talking to Mr. Davis. Mr. Davis argues to the Supreme Court that the statements that he made after he told the officers that maybe he needs to speak to a lawyer should be suppressed and not used against him in the court of law. But let's take a listen what the Supreme Court tells us.
In our Miranda decision back in 1966, we held that a suspect is entitled to the assistance of counsel during custodial interrogation, even though the Constitution doesn't provide for such assistance. In our 1981 Edwards decision, we held that if the suspect invokes the right to counsel any time, the police must immediately cease questioning him until an attorney is present. But we are unwilling to create a third layer of prophylaxis to prevent police questioning when the suspect might want a lawyer. Unless the suspect actually requests an attorney by making a statement that a reasonable officer in the light of the circumstances would understand to be an invocation of the right to counsel, questioning may continue.
But even the Supreme Court, in their own opinion, recognizes that making suspects assert clearly their constitutional rights can disadvantage certain people because of intimidation, fear, or even linguistic skills. And it also brings me to the second point. The Supreme Court tells us that the officers did the right thing by clarifying whether Mr. Davis did in fact want an attorney. And I will tell you that in this situation, maybe that's true, because after all, Mr. Davis said maybe he needs an attorney. But I will tell you that sometimes officers use this as a technique. Even when you tell them you want an attorney, they tell you, are you sure you want one? Why do you want one? And that becomes a problem sometimes. Which brings me to the final point. As you notice, Miranda rights are often litigated in court. And I think the best thing to do is not to talk to the police. Even when the officers tell you that it is your last opportunity to speak to them, that's not true. You will have your chance to talk to the officers. You will have your chance to talk to the judge, to the prosecutor, but have your attorney next to you. So if you find yourself in a situation where you're next to police officers and you're being interrogated and you're in custody, why don't you simply tell the officers you want to remain silent and you want your attorney next to you? That will probably stop the interrogation, and yes, you will probably go to jail, but later you can have a better fight in court. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.